Yep, go ahead.
Thank you. Yes, thanks very much. And thank you for the invitation to come this morning and present. It's fun to be first up for your inaugural meeting or session. So I'm Bridget Schulte-Hostedde. I'm the Regional Director with the Northern Municipal Services Office with Municipal Affairs and Housing. And I'm based out of Sudbury, and we have an office as well in Thunder Bay. So we cover kind of the entire northern geography out of our office. And I've got Christopher Brown with me this morning as well. He's a senior planner with our Sudbury office, and I'll be delivering the presentation, but Christopher is here to help with any Q's and A's that may come through afterwards as well. I don't have a ton of slides, so thinking that there may be quite a few questions afterwards, but I'll work my way through the slides, and I'm pretty happy to pause in the middle if people have questions as we go as well. So I'll start with kind of the basics about Minister Zoning Orders, or MZOs as we like to call them. And kind of to start with, the Planning Act itself, I think it's Section 47, gives the Minister of Municipal Affairs the authority to make an MZO on any land really in Ontario. And this authority has been in the Planning Act for many years now, I think almost back to kind of the original kind of early dates of the Planning Act. The authority was in place in some form or another. So there are similarities between a minister zoning order and a municipal zoning bylaw in that it does regulate the location of a land use, and it can regulate certain physical characteristics of structures on that land. So height, spacing, setbacks of those structures on the land. So something that would be familiar with as similarities with municipal zoning. It also similarly controls the use of the land. So what type of use can happen, whether it's industrial, residential, commercial, but it doesn't control the user of the land. So it doesn't control tenancy, and it doesn't control activities that might take place on that land either. If there's a conflict or some inconsistency between an MZO that's been made for a particular property and the municipal zoning that is also on that property, it's the minister zoning order that does prevail, only in the extent of the conflict. So some similarities there with your regular municipal zoning, but one key difference is that there's no prescribed or formal process to apply for a minister zoning order. So there is no application form, there's no prescribed information that's set out in the Planning Act that you have to submit if you're asking for a minister zoning order. So that is certainly a key difference, and I'll talk a little bit more about that. Next slide, please. So top bullet is quite important that minister's zoning orders are made entirely at the minister's discretion. And you may have heard that the minister has stated publicly that if a municipality or a proponent is interested in a zoning order, a minister's zoning order, that any requests must be accompanied by a council resolution of support so that the minister knows kind of what the local interest is. Similarly, he has said publicly that he expects that municipalities would have done some local due diligence as well, so that a municipality will have a sense of what are the interests of the local stakeholders or the residents of the community related to a development that might be enabled by a minister zoning order. And then, of course, not applicable in the Northeast, but the minister, you may have seen him refer to not wanting to make a minister zoning order that would enable development in the Greenbelt. So not applicable here, of course. So some of the differences, key differences really between municipal zoning and a minister zoning order is that in advance of making a minister zoning order, no notice has to be given. So we don't have to basically post a proposal on the environmental registry or in the newspaper. But notice does have to be given after an MZO is made, and that's within 30 days of that MZO being made. We have to give notice. And our typical process, or our current process for giving that notice, would be in the newspaper or and on the Environmental Registry of Ontario. And all MZOs are also posted on e-laws because it is in fact a regulation under the Planning Act. So if you're familiar with e-laws, you can go to the Planning Act and then the Regulations tab, and all the zoning orders are actually listed under there, and you can click on there and see the zoning orders themselves. Copy of the zoning order, of course, is also provided to the clerk of the municipality where the zoning order is made. There are no appeal provisions for a minister zoning order, so that's quite different. So that, you know, when the MZO is made, that it's final. Next slide. So similar to municipal zoning, when a zoning order is made, it doesn't automatically remove the need for any downstream or so-called downstream approvals. So, you know, we've seen MZOs have been made that you might permit an industrial subdivision, or at least enable an industrial use. If it's a subdivision that's planned, the proponent would still have to apply for a plan of subdivision. So it doesn't kind of address all the downstream approvals that might be needed. That includes, you know, site plan control. It includes permits. So environmental permits like a conservation authority permit or a species at risk permit, all those downstream approvals would still have to take place. Next slide. So this slide gives a bit of a snapshot on some of the changes that have been made to the MZO authority over the past year or so. And the intent here with these changes was really to kind of increase the scope and the authority of the MZOs so that the government's priorities, which I'll talk about in a moment, can be, you know, are more streamlined, it's more enabled. And fairly recently, you might have heard that recent legislation changed the Planning Act to provide that minister zoning orders don't have to be consistent with the provincial policy statement. And this speaks to kind of where I've mentioned before about the minister's sole discretion to make these minister zoning orders. So that provides some clarity on the PPS. About a year ago, there were some other kind of more complicated changes made to Section 47 to enhance the authority of the MZO tool. So we call these enhanced MZOs. And part of the reason behind these changes was to support an initiative by Ministry of Transportation called Transit-Oriented Communities, which essentially means the development of, you know, communities, so residential, employment, etc., located around transit hubs and transit corridors. It's a fairly Southern Ontario focused, you know, subways in Toronto, for example, but the transit-oriented development concept can really apply anywhere that there is public transit. Another component of the enhanced authorities, which is more applicable across the province, is affordable housing. So I'll talk a little bit about that in a second. So the chart that's on this particular slide sets out what I've called like the traditional authority for MZOs and then this enhanced authority. So some similarities is that no notice has to be given in advance of one of these MZOs being made. So that's similar across the two. And then the scope of the authority remains the same. So only related to zoning bylaws. So Section 34, 38, and 39 of the Planning Act. So that scope of authority doesn't change. But some key differences around notice. And in a moment, I'll talk a bit about what happens when someone wants to amend or revoke, which is basically to remove a minister zoning order. And with a traditional authority, if there's an amendment or revocation, you have to give notice in advance of the decision. But with the enhanced authority, you don't, or the minister does not have to give notice if an enhanced MZO is going to be amended or revoked. So a bit of a difference there. These key authorities that are new with the enhanced MZO relate to site plan and inclusionary zoning. So for site plan, the changes authorize the minister to waive the requirement to obtain site plan approval, even if the subject lands for the MZO are in a site plan control area. But the minister can require that a proponent enter into an agreement with the municipality regarding certain or all site plan matters. So it can be the removal of site plan control and that's it, or it can be the removal of site plan control plus having to enter into an agreement with the municipality to ensure that some of those key site plan matters that may be of significance for a particular site or development are still addressed. And then the second piece is on inclusionary zoning. And we don't see a lot of inclusionary zoning yet in Northern Ontario, but essentially inclusionary zoning requires a proportion of a residential development to be affordable. So it's a way to increase the supply of affordable housing in a particular community, and an enhanced MZO can help to do that. Next slide, please. Okay, so I mentioned on the last slide that once an MZO is made, it actually can be revoked and it can be amended. So by revoking an MZO, it basically erases it, or it removes it from, it's no longer in effect. And the revocation or an amendment can come from a third-party request. So in that case, there's actually an application form, there's a fee, and there's prescribed information that has to be submitted as part of that third-party request to amend or revoke an MZO. And then the minister can also independently decide to amend or revoke an MZO. In that case, unless it's an enhanced MZO, we would still give notice in advance of the proposal, and we would consider any public comments, of course, received prior to the minister considering whether to amend or revoke. I'll just make a note too that some MZOs are time limited. So the MZO will come into effect as a regulation, but it has an expiry date. So in some circumstances, then the MZO automatically is revoked upon the expiry date. So that's a little something different. We don't see a lot of those necessarily. Another thing I'll point to about revocations or amendments of MZOs is that the MZO request or the request to amend or revoke can be referred by the minister to the Ontario Land Tribunal, which is the new LPAT, which was the new OMB. It's a bit of a different process than your typical appeal. So the minister can refer the matter to the Ontario Land Tribunal. Then the Ontario Land Tribunal holds a hearing. And out of that hearing, the Land Tribunal makes a recommendation back to the minister. And then the minister considers that recommendation when deciding whether to amend or revoke an MZO. So that decision ultimately still rests with the minister. It doesn't rest with the Land Tribunal at that time. So a bit of a nuance there, which is kind of interesting. And I don't think we've had a request in recent years, certainly to my memory, of a request actually being referred to the tribunal. Next slide, please. So kind of hearkening back to my first or second slide about how MZOs are actually used, what they're used for. A few more details here that the MZOs are typically used, I would say, to permit a use. So it's enabling a kind of development, whether manufacturing, employment, residential, healthcare, but they also can be used to prohibit a use. And that has happened in the past for the protection of an environmentally sensitive feature, for example. In Northern Ontario, you may have some familiarity with MZOs. And in fact, our claim to fame, I think, is that we have some of the oldest MZOs in Ontario, because there were quite a few MZOs made historically to control development in unincorporated areas, largely around municipalities. So this was a way to try and limit that development, to direct more development to municipalities themselves. In recent years, some of those MZOs have been revoked because they may no longer be relevant, or they're so outdated that they don't, they're trying to control very minute things on the landscape that that aren't kind of don't have any impact anymore. But you may also remember just back in 2013 that the minister at the time made an MZO to permit a supermarket in the community center after the Algo Mall collapse. So, and that was actually a temporary MZO. It expired. I can't remember what the expiry date was, but it enabled that use to take place in an urgent situation. Last slide, please. Okay, so this final slide just gives a little bit of a snapshot of some of the MZOs that have been made in recent years. And I should note that MZOs can be made on private land, but they also can be made on provincially owned land. And the minister has done so to enable seniors housing and long-term care, and in some cases, transit-oriented development as well. You can see here that there are three enhanced MZOs have been made since that sort of enhanced authority came into effect. And those 3 enhanced MZOs were to enable long-term care homes or long-term care beds in Southern Ontario as well. There's also been MZOs made to enable the expansion of Sunnybrook Hospital. There have been several made, including a couple just this past Friday, to enable modular and rapid housing. So this is to increase the supply of housing along that spectrum, in particular for vulnerable people. They've been used for economic development, so manufacturing or warehousing, and also residential development. So whether it's sort of a mixed use or straight residential, to try again to kind of points to the government's priority on expanding the supply and mix of housing. So, those examples do, I think, give you a sense of the types of priorities that MZOs, or the types of development priorities that MZOs have enabled or can enable. And the government certainly sees them as a key piece of Ontario's economic recovery post-COVID as well, because they do streamline that component of the planning process around zoning. So that's the last slide. I'm happy to take any questions that you might have, and just wanted to thank you again for the invitation, and also to say that I look forward to seeing some of you at AMO in a week and a half.
Thank you, Bridget. If anyone does have a question, if they can send it through the chat function, and then I'll kind of filter them and then ask questions of either on behalf of the member, and then either Bridget or Christopher can answer the question. Actually, I was sent one by somebody from the city of North Bay just a few moments ago. They apologized that they couldn't sit in on the meeting, but they did have a question about does the municipal planning order or zoning order apply to provincially significant wetlands? If something is it's zoned industrial, but then the zone some provincial policy statements have impacted it because of provincial wetlands, and so I'm just wondering, or they're wondering, sorry, if the zoning order can apply to the to countermand the policy statement when it comes to provincially significant wetland.
Okay. Yeah, good question. So I'd point to a couple of things from the presentation, I guess. The one would be the recent changes to the Planning Act that note or that state that an MZO doesn't have to be consistent with provincial policy statement, but then also it is the minister's discretion as to which MZO will be made. So the minister would gather the information and the analysis about a particular request, and then would make his decision accordingly based on that information and analysis provided. So that's, hopefully that answers the question.
You talked during your presentation that there would be a requirement for a resolution from the municipal council. And you talked about the due diligence, talk to the neighborhood, talk to the people just so that the community is informed, and you've talked about it in open council and voted about it in open council. How old does that resolution need to be? Does it need to be a current resolution within, let's say, the last 6 months, or could it be one that a previous council had made years ago, and it now, because of the provincial policy statement and before MZOs were provided or around, the council had asked for something? Can they drag it from the past to bring it forward, or would the minister prefer that it be something new and relevant, that the municipality and the neighborhood has been heard in full open course in council, as opposed to something that was just picked out of a back pocket and brought forward?
Sure. So I would hesitate to speak. I wouldn't speak on behalf of the minister.
Oh, go on. You do it all the time.
But I would suggest that a recent resolution would probably have more significance than an old resolution, just because the minister would want to be comfortable with the current interest, right? Current situation, current environment, and the current perspectives of the stakeholders and the public, and that municipal council, of course, itself.
The other question that I've just received, texts are wonderful things. I didn't realize my phone number was out there that much. I'm just wondering, has the minister to date done a municipal zoning order in the unincorporated area? They're concerned, the community is concerned with, if there's going to be business or industry, they would prefer it be inside municipal boundaries, so that for taxation, and they realize that the employment, they may leave in their community, but it's the revenue generated by having employment in business or industry in the municipality, as opposed to across a boundary, and it's in an unorganized community. So I'm just wondering what your thoughts are in regards to that question.
Yeah, so of course, the municipal service office does do development approvals in the unincorporated, where there's no municipality, when it comes to land division, for example, and we are very aware of the importance and the importance of having that development happen within a municipality for taxation purposes, services, etc. The MZOs, those historic MZOs that I mentioned, many of them were made for exactly that purpose, to control the development around a municipality, to direct the majority to that municipality. So there hasn't been an MZO made in the unincorporated in recent years. I think the most recent may have been in the 90s, early 90s maybe, but many of them are from the 70s and the 80s. So yeah, if there is an interest in one, it would, again, there would need to be a request for it. And then we would do our, due diligence in the background to look at, okay, what's being proposed and why. It can get a bit tricky, I would say, if a landowner themselves doesn't want an MZO. So that would have to be part of the consideration, of course, as to who is asking and why, and the implications of putting the MZO on a particular property.
So Bridget, the next, to maybe expand on that last question, will the neighboring municipality be notified of the MZO request from the from a property owner in the unincorporated area? If it's right across the property line, will the neighboring municipality have an opportunity to be informed about it, and then also to make comment one way or the other in regards to the application?
Okay, and maybe I misunderstood the first question. Your first question was about someone like a landowner wanting an MZO. Right. Okay, sorry, I thought that you were suggesting an MZO to prohibit development, but you're talking someone might want an MZO to enable a development. That's right. Okay.
Correct. Sorry, that was my
no. So would an adjacent municipality get notice? Well, if it's a new MZO, there wouldn't be notice in advance. The notice is only required upon the making of the MZO. Although, you know, during the due diligence process, you know, typically, or there may be, or there can be outreach to a particular municipality. So it's kind of uncharted territory, I'd say, because there hasn't been one made in unincorporated in many years. So yeah, I can't really say yes or no. When it comes to giving notice of the actual, like if an MZO was made, I think probably we would, you know, it would be posted on e-laws, it would be posted on the ER and the environmental registry, but there wouldn't be a requirement for us to give notice to an adjacent municipality, but the MSO, we probably would let you know because we would know that you were right next door. But yeah, again, not a prescribed process.
Just, you know, lots of municipalities, doesn't matter the size, aren't necessarily going to the environmental registry every day. Yeah, they're not going to e-laws to see what's going on. So yeah. I'm just wondering if, hearing your answer, if there was, you know, if a municipality is within, 10 miles of a development, then it might be best practice to touch base with that community, and pick a distance, and just so that they're aware of what's going on, and so that they would have an opportunity as a council to make comment in regards to the proposal. Just maybe just so that they know what's going on in their neighborhood.
Yeah, no, I appreciate that. I appreciate your point. Thank you.
Okay. Well, we've just hit 9 o'clock, and thank you very much to Bridget and Christopher. Great job, Christopher. And just thank you very much for being our inaugural guests in the Learning Mornings, and we look forward to hearing you at AMO in just a few weeks. Great. So just for everybody's information, the next speaker will be Michael Borelli from Nuclear Waste Management Organization. We'll take a 5-minute health break. So we'll start with Michael at 9:05, and I'll blank my screen so you don't have to look at me for the next 5 minutes while you take care of a few things. Thank you.